first case, it was State versus Otero, and both sides will have the 15 minutes to present your arguments, and obviously you both know the rules, you've been here many times, but we just try to remind everyone not to mention victims' names and not to mention children's names, and also the appellant, which is the state of Ohio in this one, you can reserve up to 5 minutes. Before we get started, though, I just wanted to acknowledge something. Judge Callahan, I just realized I was thinking she was going to be with me forever. Unfortunately, she's not, as we all know, and this is her last time sitting for oral argument in Lorain County. So I want to acknowledge that and thank her for your years of service. We appreciate that. Thank you. Okay.
What better way to end, though? I mean, really, isn't that true?
So when you're ready, Chris.
Thank you, Judge.
Let's go.
Good morning, Your Honors. May I reserve 5 minutes for...
You know, this is, I don't know, we used to use the small one. I don't even know what we're using anymore.
For...
Hold on for a second. Kit, can we still use the small one? Or?
If you wouldn't mind using the small one, that
Oh,
way
yeah.
the camera is aimed.
Absolutely.
Thank you.
I didn't
A
know.
little closer to me.
You guys just land. Okay, all right.
May I reserve 5 minutes?
Sure,
Thank you.
that's fine.
May it please the court, I'm Rick Raley. I'm appearing today on behalf of the Lorain County Prosecutor J.D. Tomlinson and the appellant in this matter, the state of Ohio. And I'm here to ask that this court reverse the trial court's order in this matter that dismissed this case for a speedy trial violation. And there's 2 alternative reasons, 2 assignments of error that I present. Each one of them is independently sufficient to reverse the trial court's judgment. And I'm going to focus on the first assignment of error because it's more of a substantive question there. And that's that I think the trial court caused an error by finding a speedy trial violation. There were 270 days to try this case. By my calculation, there were 167 days that counted against the state in this matter. So just going through, this is a subsequent indictment case, all of which the charges relate to a search of the defendant's residence and the adjacent premises there. There was a significant amount of cocaine and fentanyl found in the defendant's person, as well as items related to drug trafficking in the house. At the time of the warrant execution, police also discovered a significant amount of fentanyl in a baggie that was in some overgrowth outside of the house in an adjacent yard. So, in case ending 207, which I call the previous case, the defendant's indicted on the charges all relating to everything that's found inside the house and on his person. Now, at the time that that case was indicted, the investigating police had received a BCI report indicating that there was DNA from this defendant on the baggie for the drugs found outside of the house. However, there were no charges that were presented to the grand jury about those drugs at the time of the initial indictment in the previous case. So this case goes through, the previous case goes through the pretrial process. There's a variety of tolling events from defense continuances, from defense motions. I direct the court to my reply brief, page 4 and 5, which outlines my view of how the speedy trial calculation should be done in this case. It's very important. The pretrial entries all say that pretrials are continued at defense request, and it provides the next day. I believe that means that it counts against, well, it doesn't count against the defendant, but it's not charged for speedy trial time.
Counsel, can I ask you a procedural question?
Yes, ma'am.
I know these 2 cases were indicted separately, obviously. What was the status of case 1, the subsequent, no, that wouldn't be the first case, let me rephrase that, I'm sorry. They were never joined, is that correct?
They were never joined, that's correct.
All right, so the first case actually went to trial and was tried and
It actually ended in a guilty plea in May of 2021.
well, when that happened, what was the status of the subsequent
The
case?
subsequent case had not been indicted yet.
Thank you.
The subsequent case was actually indicted once sentencing had occurred in the first case.
Okay. And how long after the BCI information came in did that happen?
So the BCI information came in October of 2020, and it was indicted in July of 2021. But since it relates to the same facts and circumstances as the previous case, I believe that the Supreme Court's ruling in Blackburn applies. tolling events from the previous case would apply to the subsequent indictment.
All right, and you're not, my understanding is the state is taking no issue. You're not arguing that that did not relate back. That was a double negative, I apologize. You're going with the fact that it related back to the first case, but the tolling events.
Correct, it related back, and that's why the tolling events would occur. And there was some confusion, and we can see that in our brief, that initially the state took a different position in the trial court proceedings. However, by the time the motion was argued, the state had filed a supplemental brief that raised Blackburn and argued based on that at the actual hearing on the motion to dismiss.
Thank you.
So, looking through all these tolling events, I think that it's pretty clear that there's only 167 days because a lot of time was tolled based on pendency of motions, including the motion dismissed in the current case. Reading the appellee's response brief, there is some dispute about whether the triple count provision applied at the beginning of the subsequent case, this case. I contend that it does not because he was being held on his prior guilty plea and prison sentence. However, even if the triple count provision did apply, there's still sufficient time for this to be reversed and for the trial court to look at this again.
Counsel, the other thing that I was wondering about, I'm glad that Judge Callahan asked the procedural question, but, because I was a little confused over that as well. But I'm also a little confused as to what evidence was actually presented. In other words, there seems to be a little bit of disagreement as to who has the burden of proof in regard to all this. And it does appear at times that the state is saying, well, the defendant should have had that information, and I'm not sure whose burden it was when. And I guess the reason why that kind of becomes important is, for instance, when you just said he was being held on an actual imprisonment, that he was here at an actual conviction, was that information provided to the court, and in what manner?
I believe it was provided at the motion hearing and in our briefing to the court on the motion to dismiss. And I will say that it is the state's burden to prove tolling events. That is absolutely accurate. To the extent that there really isn't a lot of reasoning or analysis, that goes to the second side of that the state presents, that the court did not provide findings of facts regarding those tolling events. However, I think that it's pretty clear from this procedural history that the court can glean what was a tolling event and what would a charge the state held on. And just finally, before I conclude this opening part of my argument, I really do think that the 10th District's decision in Hernandez, which is cited in my brief, is very instructive on this. Very similar facts there. There, the original case involved drug trafficking charges. Later, the state added firearm specifications to the exact same facts in a subsequent case. The 10th District said all of the tolling events from the first case applied to the second. I think that's very similar to what we have here. If there are no further questions now, I would save the rest for rebuttal.
Thank you.
Thank you, Your Honors. Giovanna Bremke on behalf of Mr. Otero. I'm glad to be back in person today for the first time. As the state mentioned, this is all about speedy trial, and I think it's worth noting that speedy trial is what is adopted by every state constitution, our state constitution, the United States Constitution, and it's very important. And the reason for that is for this very instance, when the state screws up, when they have forgotten, and that's what happened in this case, and that can't be held against the defendant for various reasons, because he's sitting incarcerated, or it's harder to get evidence. Further, I think the timeline is important because that is another reason that this is something that it was intended when speedy trial was adopted, to make it so that the state cannot bring one case and then another case and then another case, and without having they're suggesting that they get all of this additional time. What's to prevent them from filing a third case now? Because they had this evidence, they had the lab results. So I think it's important.
Let me ask you a question.
Yes.
The prejudice that you are talking about, which is the reason for the speedy trial. Doesn't the fact that the state is conceding that the second charge relates back, you know, whether or not the judge did, I'll get to that in another question, but doesn't that kind of eliminate the prejudice, or some of the prejudice? I mean, there was either tolling or there wasn't. It's not like they were trying to start fresh.
Yeah, well, I disagree, and I think the timeline is important. He pleads in May, he goes for sentencing and gets served with his new indictment. So that's right there showing, hey, we'll do one case and then another case and then another case. That is exactly what we're intended to prevent. Do people have this, ongoing case about the same exact subject matter? And I did spend some bit of my time in my brief talking about how this relates back. The state is conceding that now, but it's worth noting that this is their third set of arguments about the speedy trial calculation. That alone shows they haven't met the burden. At first they're saying it doesn't relate back, and then there's an entry saying it does relate back, and now they're disputing the time, and it's even a different time than what they proposed in the trial court.
Let me ask you one more question then.
Okay.
Regarding all your arguments and the state's arguments, and there's, 3-day jail count, no 3-day jail count, relating back, not relating back, tolling, how are we supposed to know how the judge made the decision in this case? What are we supposed to review?
Okay, so that's a good question. I think, to this court is to review the record that's before us, and there was a hearing, because I have had another case where there wasn't a hearing, and I don't think this court looked very favorably upon it, because there was no record. But here there was a hearing. There was one witness that the state presented, and it was mainly factual, because again, at that point, there was a big question about whether it related back. The state's brief originally says, hey, and this is worth noting as well, a tip came to us that there was drugs in a fence post. The second case is about drugs in a fence post. So this isn't, this is not something that wasn't contemplated. So I think that this court, I think that with the judge's entry, number one, that wasn't objected to. Upon the dismissal, there was no motion after that. Number two, it only dismisses certain counts. So because the state is agreeing that it relates back, it's all one indictment. It's all, one indictment. So what the 48B, says is if you dismiss the indictment, then you have to make those findings.
We have two different case numbers here, correct?
We do, and yes. So in the state made an issue, I even have here case dismissed on there. Case is separate than the indictment, and for purposes of speedy trial, they relate back. It's a supplemental indictment. It's not, these are additional charges to the same indictment, the same set of charges, the same facts. So for purposes of this, he's only dismissing these subsequent charges that have come. But I would argue that 48B does not apply.
If it was actually a supplemental indictment, wouldn't it have been supplemented to the first case number?
Well, another procedural thing is that the state asked to consolidate these cases. That, again, at the state's request.
So were they consolidated?
I don't know the answer to that. That was the entry that said these are the same facts and circumstances as this other case. And I believe it said that the state would file a motion to consolidate. I don't know if that ever happened. And I will note again, as to the second assignment error, the law is clear even from the 9th district that the court does not have to have a hearing on it. And I would argue that because the 294573 requires that the court dismiss, then that the statute would apply, and that those findings weren't needed, in addition to my argument about it being not the entire indictment. I did put together a chart for you about the different tolling events. It is very technical. One of the things I want to mention is the triple count that my colleague mentioned, and note that there's a Dankworth case that specifically says the triple count applies on that subsequent case, even after there's been a guilty plea. I agree, that time was after he was serving time on the prison sentence, and it is unique because what we know is if people are being held on 2 cases, they generally don't get that triple count. But in speedy trial, it's different, and it relates back. In that point, that Dankworth case is directly on point with that. Another issue is the entries, these pre-printed entries, and there's an O'Hara case that I cite that says the trial court is in the best position and they're best able to characterize the nature of these pre-printed entries. This court, various courts have held that these pre-printed entries are not favorable, either they're not the best. And many of them do say they're at the defendant's request, but I will note, and what the record will show you in this case, is that Mr. Otero never signed not one of them. So to have those held against him, anyone, I guess, can write anything on an entry, but if it's not signed by Mr. Otero, most of them, I think only one is signed by his counsel, how can those be held against him when this is a state's entry? Most importantly, the state, again, has the burden of proof here. And what the law says in this case, and it's cited over and over in my brief, that the speedy trial calculation has to be construed in favor of the defendant. I've cited in my brief that the trial counsel for the state said, hey, we screwed up here, we screwed up. And that's what speedy trial is intended to prevent. And they've presented 3 different arguments as far as the calculation. That's right there is alone proof that they didn't meet their burden. They presented 1 witness, and it was a factual witness. And, it was not, what we're here about is these tooling events. It's not about factual, it's not about whether it relates back. What your whole, analysis is going to be what told and what didn't. And what can be construed in favor of the state or against the defendant, whatever it may be. But there simply just wasn't enough evidence there. There's cases that, again, that I've cited that speak to if the state has not met their burden, then you have no option other than to uphold the trial court's, judgment here in dismissing this case. And that's what I would ask that you do.
Counsel, how do you, I know you talked about this a little bit, but could you just more specifically address the second assignment of error?
Yes. Okay, I'd love to. So, several of my arguments. I would say 48B is not applicable because it was only part of the charges, not the entire indictment. If you read 48B, it says the indictment. These were only, certain cases, certain charges, I'm sorry. It was a new case number, I'm not going to dispute that, but that does not mean that it wasn't the same indictment. The state had asked to consolidate, they have said it relates back, they're now conceding that. So, in that regard, this is all, it's all, for purposes of this, all one indictment, for purposes of calculation and all of that. This is only part of the indictment. Additionally, I would say that the, again, 2945.73B says that the court shall dismiss if, speedy trial is violated. And so the court has to follow the statute, and the statute overrule is superior to the rules in this case. 48B is just a rule. So the court had no option other than to dismiss at that point. And again, lastly, I think that the court didn't have to have a hearing. They didn't have a hearing. The entry attached is the only thing to that regard, although the court did speak on the record. And so, again, I think that the court could either speak on the record or in its entry, and the court did engage in that hearing.
So did the court give some analysis during the hearing?
I don't believe the court had decided at that point, but the court did engage in that hearing. Any other questions? Thank you.
Here's not, thank you. Attorney Rainey, you have your full 5 minutes.
Thank you, Judge. I just want to clarify a couple matters. First, about the consolidation. There is a co-defendant that is involved with this residence, and the state's motion was seeking to consolidate the previous case with the case involving that co-defendant because of the joint circumstances of this offense. I'm not asking the court to hold anything against the defendant. I'm just asking the court to apply the tolling events that are provided in the statute. And I believe that the trial court was provided evidence about those tolling events, and it should have engaged in analysis and found there was not a speedy trial violation. I think that there's not a distinction here that says 48B doesn't apply because this is a subsequent indictment case. I think it's pretty clear that with these factual issues put before the judge, that there should be an entry that would resolve some of these questions about reasonable tolling events, what applies to triple count, all of those items. And just to clarify, it's not the state's judgment entries about these pretrial entries. They're all signed by the judge. They're the court's entries. It is the practice here in Lorain County that the prosecutor will draft it initially, and they'll go over it with defense counsel. Defense counsel's still around. They go away to another hearing. But then ultimately, the judge was there. The judge knows what's going on. The judge signs the entry or not. In this case, there's no indication in the record that there wasn't some sort of dispute about what was going on with these dates. That's just, it's all speculation on appeal. So, Your Honor, I think there's clear evidence here that there should be a reversal of the trial court's order. If there's any further questions, I conclude.
Anything else? Thank you very much.
Thank you.
Thank you both for your presentations to the court. And the court will take the matter under advisement, and the court will issue a written opinion as well as obviously release it online. So thank you very much.
Thank you, Judge.
Enjoy the rest of your day.